Please be seated.
I think we can resume, but I want to verify with Mr. Cobble. If we need to get more of a break, we can take it.
I'm fine, Judge.
Are you absolutely sure?
Yes, ma'am.
Mr. Cobble left probably, I call it everyone's attention, perhaps 3 minutes before I stop things. Can you back up your argument a little bit for his benefit?
Yes, Judge. I think I was in the midst of talking about 404B, and in arguing that, Judge, I was just arguing that if for some reason Your Honor did not find that this met intrinsic evidence or motive evidence outside of 404B, which we believe it completely does, we believe that in any event, had it not been indicted together, it would be admissible under 404B for the purposes of circumstances surrounding the charged crime, motive, intent, and absence of mistake. Also, I've gone into the fact that the proof of circumstances immediately surrounding the charged crime, in this case, would involve and be leading up to acts occurring with CD involving personal and sexual nature up to and on the day of the actual murder. Also, as discussed in subsection B, this would be admissible as motive, if not as intrinsic evidence and outside of 404B, but also pursuant to 404B. In United States v. Poole, the defendant was charged with a conspiracy to commit mail fraud and wire fraud in connection with the murder of his adopted parents. The court admitted, the 11th Circuit admitted infidelity and extravagant lifestyle for the purpose of showing motive pursuant to federal rule of evidence 404B. Hill v. the State is a Mississippi case where their Rule 404B is patterned after ours. In that case, the defendant murdered her child and evidence of motive was admitted. As we've been arguing about, I believe the defense had made arguments regarding this was so attenuated and basically insinuating this was some crazy motive. This is just another example to show that while the defense may say this is crazy, it is real and it is pervasive motive evidence in this case. In Hill, the woman defendant in that case bonded out of jail after being arrested with her husband. The arrest was admitted at trial. She bonded out and killed the child, the motive being to collect life insurance money just so she could afford to bond the husband out of jail. Regarding the introduction of evidence under 404B, if it was necessary for the purposes of intent, accident, and mistake, as Bradshaw held, the defendant puts the issue of intent in question when he enters a plea of not guilty. Also, malice is a state of mind and frequently must be proven indirectly. In Lackey v. the State, it was a case that held whether a child has been neglected and abused with malice as to constitute murder or has merely been harmed as a result of inability, carelessness, or accident, it may often require considerable indirect proof to determine the defendant's state of mind. The evidence related to the offenses committed against CD are significant evidence of the defendant's intent and state of mind leading up to and on the day of the murder of Cooper Harris. And finally, Judge, as I was getting to, I think right before we broke, just briefly, the defense didn't argue much of this in their argument. It was argued in the brief, so I'll address it. They alleged that the offenses were joined solely to put bad character, interject bad character as the defendant. I know you've heard this a million times, but just for the record, Washington v. the State is an example, 294-560, 2014. If, quote, evidence of other acts is relevant for some other purpose than to show probability the defendant committed the crime because he is a man of criminal character, the evidence is admissible despite incidentally placing the defendant's character in issue. Further, the state is authorized to present evidence of possible motive for committing the crime, and such evidence does not become inadmissible merely because it incidentally places the defendant's character in issue. So, Judge, I believe it is clear, and I'm asking you to deny the motion to sever in that the evidence would be admissible at trial, the relationship and the evidence for counts 6 through 8 in the trial of counts 1 through 5. They are necessary to complete the story of what happened, to put the crimes in context, to give motive to why the defendant would have done something so horrible to his own flesh and blood. And I believe that the proffer and the evidence that we expect to show relevant to that, it can't be more apparent than in the defendant's own words, that he loves his son-in-law, but they both needed escapes.
Mr. Kilgore, did that back up adequately for you?
Yes, Your Honor.
Do you have further argument? Or did we need to take a vote? We can do
No,
both.
just real briefly, Judge. All of the cases that I cited to the court specifically deal with improper joining. I think that counsel's brief and argument, although very well written and researched and argued, really all he's arguing is that the evidence that he suggests would come in as to count 6, 7, and 8 is admissible in the trial of the case. That's why he's arguing all 404B and all that. That doesn't end the inquiry. Even assuming perhaps that the evidence would come in. Okay, that's another argument for another day and perhaps another motion. But I addressed this very matter when I initially addressed the court, and I'll give you one more case that states it very plainly. Stewart versus the state, 277 Georgia 138. That's a 2003 decision. The fact that evidence of one offense would be admissible in a trial of another offense is a relevant consideration in determining whether to sever. But it does not in the inquiry. The trial court must still determine if severance of offenses would promote a fair determination of guilt or innocence as to each offense. I'd ask the court, take a look at the cases that I've provided that deal specifically with the issue of improper joinder that we've got here. Again, this is very eloquently argued by counsel. This is very impressive brief. But all he's dealing with is this evidence is admissible, so that's the end of the inquiry. It's absolutely not.
Thank you, counsel. The defendant's motion to sever is denied. Severance of the counts in this gold indictment are not legally required, and the evidence of the offenses involving CD are likely to be admissible in the trial of the offenses related to the murder of Cooper Harris. And of course, the court has not ruled on the admissibility of that evidence. But regardless, the evidence relating to the offenses involving CD is admissible, possibly admissible upon the trial of the counts related to Cooper's death for the following reasons. It can come in as intrinsic evidence or as evidence of motive or malice, and also the defendant's state of mind leading up to and on the day of the murder, which would address the count 3 issues raised and articulated by the defense. And also the 404B arguments offered by the state are persuasive. For those reasons, the court will not sever counts 6, 7, and 8 from counts 1 through 5. I direct the district attorney's office to submit and prepare an order to that effect. Send a copy to the defense for review, and I'll reserve it for probably 5 or so days for any response you may have to take that into account into the final order of the case.
Thank you, Your Honor.
Are there any further matters? These are defendant's motions today.
I don't think we've got anything else that the court needs to hear today.
And for the state.
Nothing further, Judge.
Alicia, I want to raise the scheduling. I am scheduled all the way through January of next year. I'm booked solid. So I think that we need to get some court dates, at least tentatively scheduled. Brian, can you give me one? I am proposing that we schedule this the week of February the 22nd. Because if you all don't get on my calendar, those days will be gone. Does the state have any problem with that?
State has no problem with that, Judge.
For the defense, Mr. Gilbert?
I would suggest to the court that there will, other than the December dates that are scheduled, there's almost certainly going to be additional dates needed to hear certain motions in limine. I don't know if the court has dates prior to February the 22nd for that or not, but I do think that's one thing that needs to be taken into consideration, and the scheduling of cases is at the court's discretion. But at this time, before we've even heard several very significant motions that we've got scheduled for December, we're not be in a position to announce that we're ready in February.
I understand that. I want to get you on my calendar and make it a goal to try to be able to try it at that point, understanding that other things may occur that make that not feasible. So I'm going to go ahead and reserve those dates for you all. I don't want to set the motion in limine up yet. I prefer to wait till December, because whatever, except for the things that I have to cover, I can get someone to cover my other court things, like this morning was covered by Judge Brantley, so that we can have these motions. So there's some senior judging available to help cover for the motions in limine. It may well be that the motions, are you of the opinion the motions in limine need to be heard and decided before jury selection?
Yes, ma'am.
Okay, just.
I would agree with that, Judge.
That's not a
Some
problem.
of them may have to do with redactions, other very specific pieces of evidence, specific witnesses.
And trial preparation. Sure. I don't mind that. I'd like to wait until we get through the December hearings and then revisit the future scheduling, including the date for hearing the motion in limine, how that will impact this February time frame. Let me ask you this. The December hearings, the motions, how many days are they scheduled for?
I think we have them the 14th, 15th, and then if necessary, we have the 19th at the end of the week to conclude them. So I think 3 days total.
Is it feasible to do the motions in limine? That's 3 days. Is it feasible to do them then?
I don't think we'll be prepared to argue the motions in limine in December.
Okay. How much time will you need between the December hearings and hearings on the motion in limine?
I think that the suppression motion scheduled for December, I think it's very realistic. We could finish those in 2 days or 3 days, and we've got 3 days scheduled. As far as other additional motions in limine that would come after, I don't see any reason to think that two days wouldn't be more than enough.
And how much preparation time do you need?
Probably end of January. That would give us some 6 weeks after the suppression motions.
But that bumps up too close to when I want to try this case.
I understand. I understand that, Judge, but as I said,
Oh, you said into January.
end of January.
Yeah, you said into January. Okay, the 25th.
Okay.
There you go. You need to look more careful. All right, let's set this down. Brian, am I supposed to set the time to be on January 25th? January 25th, to have a special set? No.
It would be like you said, to, continuation.
I'm wondering about Someone came on specify, is that a conflict with the, Winfrey case?
It's a conflict with the case that I have, especially set in front of Judge Poole. I know that's a trial week for many of the judges, so if it's possible to do the week prior or even the week before then, that would be better.
I think the problem, Judge, is the Winfrey case is going to happen at some point, I know, during then, and then before that, you got the judges' conference, the winter conference for prosecutors, things like that, and the Martin Luther King Jr. holiday kind of butting up around that, leading up to it.
We do it on the 22nd. I'll come back from the conference. By then, whatever I'm responsible for, I'll have done. Because I know that the 19th, the 20th, probably the 21st, I'm either teaching or conducting business at the judges' conference. But I'll just come back on the 22nd. I'm ahead on my education. So we'll do it on the 22nd.
Thank you, Your Honor.
What month?
January. Okay. All right, that gives you an extra day, and if you need more time, I'll figure that out. We can work on Saturday. All right, anything else with the state?
No, Your Honor.
Floor to defense?
No, ma'am.
Thank you. We're recessed.
Yeah.